Thank you, Chairperson Bennett. Yes, I believe we've got the call going. I'll go ahead and hand it back over to you.
Okay, by the way, do you have the remarks we're supposed to read when we start one of these, Andy? About it being a Zoom call?
Sure, just a second here. And if one of the revisor staff has that handier, I might defer to them if they have it.
Yeah, Jordan, this is Natalie from the revisor's office. I have it right in front of me, so I can go ahead and read it.
Would please, thank you.
Due to health and safety concerns, members of the public are not in attendance at this meeting, but full access to this meeting is being conducted by medium of interactive communication, allowing members of the public without cost to listen to the meeting through the use of live stream audio broadcasting on the internet and teleconference is available. Information on how to access this meeting was sent out with the notice for this meeting. The agenda for the meeting was included with the notice and may be requested from the Office of Revisor of Statutes using the Office of Revisor of Statutes official website at ks.revisor.org. Any other documents presented during this meeting will be available on the website and from the Office of Revisor of Statutes. Each member of the commission and staff will state their name and title each time the individual begins speaking or voting so that the individual can be readily identified by remote listeners. All participants are required to ensure that microphones, phones, or other electronic devices are muted when the participants are not speaking so that the ability of remote listeners or observers to hear the proceedings is not unnecessarily impeded. Public comment will not be allowed at this meeting. During the commission meeting, the commission will not recess to a closed or executive meeting pursuant to KSA 75-4319. And each motion, if any, will be clearly stated before the commission votes, and the chairperson will announce the results of any final vote. And that's it.
Okay, thank you. All right, well, if memory serves, Jordan, the next thing we're supposed to do is do a roll call so the listeners know who's on the call. Is that correct?
That's correct. I've got the roll sheet here, so I'll go ahead and begin.
Right.
Chairperson Bennett.
I'm here.
Vice Chairperson Owens.
I am present.
Senator Haley. Senator Wilborn. Representative Finney. Chief Ackerman.
Here.
Jennifer Basinger. Judge Brown.
Here.
Sheriff Carr.
He let me know he's going to be tied up. He'll try to make it later.
Thanks. Judge Clark.
Present.
Oh, very good.
Professor Francis.
I am here.
Thank you. Chad Harmon.
Here.
Spence Cohen.
Here.
Tabitha Owen.
She's unavailable this afternoon.
Okay. Sylvia Pinner.
Here.
Bill Persinger.
Here.
Professor Phillips.
Here.
Pastor Robertson. Shelley Williams.
Here.
General Schmidt.
Assistant Attorney General Jessica Domi on behalf of Attorney General Schmidt.
Thank you, Jessica. Executive Director Scott Schultz.
I am present. Good afternoon.
Thanks, Scott. Secretary Zamuda.
I'm here.
Thank you. Moving on to staff, Connie Bonner.
I'm here.
Thanks, Connie. Robert Gallimore.
I'm here, Jordan.
Thank you. Myself, I'm present. Malaysia Shigen.
I'm here. Thank you, Jordan.
Jenna Moyer.
I am here as well.
Thank you. Natalie Scott.
I'm here.
Jason Thompson.
Here.
All right, and then I've got a list of conferees here, so I'll start with that. We've got Executive Director of the Board of Indigent Defense Services, Heather Cessna.
I'm here.
Thank you. And with the Council of State Governments Justice Center, Patrick Armstrong.
I am here with the rest of our team.
Okay. Would you like me to go ahead and read down the list, Patrick?
I can just tell you who's here. We have Carl Reynolds, Jen Casella, Sarah Wurzberg, Erica Nelson, Josh Gaines, and Laura Vanderlook.
Okay, thank you, Patrick. Is there anyone else I might have missed who's here in our meeting?
Gail Finney.
Thank you, Representative. We'll get you noted on the list. Is there anyone else who I might have missed?
This is Rachel Druckhammer. I'm also with the Council of State Governments.
Thank you, Rachel. Is there anyone else I might have missed on our list here? Okay, I'll hand it back over to you, Chairperson Bennett.
Very good. All right, just a quick recitation. We're going to hear first from Heather Cessna, the Executive Director of the State Board of Indigent Defense Services. She's going to give us an update on the work she's been up to and the request that she's going to put to the legislature this year. I think it's important for us to note this in terms of fabricating or putting together our own December 1st report, whether we want to include, and to the extent that we want to include some of her recommendations in that. We're going to then switch to give her about 15 minutes, then we're going to turn it over to Patrick and the folks at the Council for State Governments. They've been, for the listeners, this is an entity that has been in the state of Kansas and working with all the subcommittees, doing lots of interviews, talking to the stakeholders in the various judicial districts and all the counties. And they've come up with quite a bit of, not only research, but some recommendations as well. So we'll turn the floor over to them. After that, depending on how much time where we're at, we'll probably take a break. And then we'll hear from the individual subcommittees as we work toward our goal here in the next really a month and a half to finalize our what at this point is our final report to the state legislature, which is due December 1st of 2020. So that's a quick update on where we're headed today. So with that, I'll turn it over to Ms. Cessna.
Thank you very much for having me. This was Heather Cessna. I'm the Executive Director of the Board of Indigent Defense Services. And I've got a presentation here to share with you all today. So I will get that started. And let's see, I have not started this up. So all right. Hold on a second. Looks like I need to switch which one I'm sharing. You know, it wouldn't be fun if it wasn't a little bit of technical difficulties here. Let's see. Let's switch here and get this going. Try this again.
We've got your public defense in Kansas. Looks like an orange colored background PowerPoint.
Yep.
There we go.
You can see it now. All right.
Yep.
Perfect. All right. As I said, I'm the Executive Director of the Board of Indigent Defense Services, and I'm here to talk to you about the Board of Indigent Defense because we've got quite a bit of things going on these days, and we wanted to share both the status of our agency as well as some of the requests that we're making in our upcoming budget requests. So I appreciate you guys giving me the chance to come talk. One of the things that I wanted to start off with was talking to you about some of the issues that BIDS is facing right now. Those include high caseloads for our public defenders and our assigned counsel. They include a lack of pay parity and other compensation issues, a lack of sufficient staffing and other basic infrastructure resources, all of which have been exacerbated by the impact of COVID-19. Essentially, we're at a breaking point at this point. But one of the points that I wanted to bring to this commission is that BIDS's problems aren't just BIDS's problems. Our problems have a huge impact on the rest of the Kansas criminal legal system. 85% of adult felony charges in Kansas require appointed counsel, and we provide all adult felony appointed counsel either through public defenders or through the assigned counsel program. In fiscal year 2020, we handled just over 26,000 cases. This was approximately 15% lower than in fiscal year 2019, primarily due to the sudden fourth quarter slowdown in new cases and cases completed due to COVID-19. Out of those cases, just over 11,000 were handled by public defenders and almost 15,000 were handled by assigned counsel. The reason those numbers are important is because consistently public defenders are more economical. In fiscal year 2020, our assigned counsel cost us $175 more per case than if a public defender had handled the same case. Our most immediate problems in our agency right now are our caseloads. The National Advisory Council and the National Association for Public Defense set national standards for an absolute maximum caseload for defense attorneys at 150 felonies per year per attorney, 400 misdemeanors per year per attorney, and 25 appeals per year per attorney. And these are relatively old standards, but that's what we're using to help illustrate for your purposes today, so you can kind of see what this looks like for us. The problem with high caseloads is that it deters people from becoming public defenders or joining our assigned counsel appointments lists. High caseloads drive mission-driven employees away from our agency. For example, a recent employee survey of our agency found that while 81% of our employees come to work in public defense because they believe in what we do, that 55% reported that within the last year, they'd considered leaving public defender offices in part due to caseload issues and pay issues. Our high caseloads are also an effectiveness issue. When you have too many cases, you simply don't have enough hours in the day to do all the things that you need to do to be able to represent those clients effectively. And this is why those high caseloads are also an ethical issue. Because the Kansas Rules of Professional Conduct for Attorneys, Rule 1.3, Rule on Diligence, Comment 1, specifically explicitly says a lawyer's workload should be controlled so that each matter can be handled adequately. When attorneys cannot handle their cases effectively because of high caseloads, that causes a number of down-the-line consequences. Those include expensive and time-consuming post-trial litigation, such as viable claims of ineffective assistance of counsel, wrongful conviction lawsuits, legal malpractice claims, ethics investigations, and the potential for protracted and expensive litigation over the constitutional adequacy of the public defense system as a whole. But most importantly, high caseloads impede our ability to provide our core agency mission, which is to give our clients a zealous and effective criminal defense. But when we're talking about this 150 limit caseload, I wanted to illustrate what that really means in practice for our offices. In fiscal year 2020, only 3 of our 11 trial public defender offices were able to be just at or under that 150 felony per year per attorney absolute maximum. However, even those offices had to pay a price in order to do so. For example, our 3rd Judicial District public defender in Topeka was right at that 150 threshold, if you look at these caseload averages. But that office also had to refuse new cases for a total of 172 days in fiscal year 2020. So in short, they met that 150 cases per attorney per year threshold because they had to refuse new cases for 47% of the fiscal year. A similar situation occurred in our Sedgwick County Conflicts Office in Wichita. They averaged 143 cases per attorney per year, but refused new cases for 133 days, or 36.4% of the year. You can contrast that with our main Sedgwick County Public Defender Office, which had our highest average caseload among the trial public defender offices at 278 cases per attorney per year. That office only refused cases for 55 days in fiscal year 2020, or 15% of the year. That office also, unsurprisingly, had some of the most chronic turnover problems of all of our trial offices in fiscal year 2020. On average, our trial public defenders were carrying approximately 205 cases per attorney per year in fiscal year 2020. That's 55 cases above the absolute maximum national standards. So practically speaking, What does that mean when we say that an average caseload in Kansas for our trial attorneys is 205 cases per year? Well, that means that that attorney ends up having only approximately 10 hours per year to work each of those 205 cases. For perspective, a recent study of Louisiana public defender caseloads found that a lawyer should spend approximately 22 hours working on low-level felony cases for reasonable effective assistance of counsel. That same study found that a lawyer should spend approximately 200 hours on a felony case, carrying a sentence of life without parole. And these trial offices are handling everything from probation revocations all the way up to off-grid, premeditated first-degree murders, and Jessica's laws with life sentences. And the thing that you have to remember about our system in particular is that we don't have any control over our caseloads or how many cases come into our system. Our caseloads are entirely controlled by the legislature, who decides what to criminalize and what crimes to make felonies. The prosecutors who exercise prosecutorial discretion over which cases to charge, which cases to divert, and which charges to include in any given case, and how much crime is actually happening. So what happens when public defender caseloads and a lack of appropriate attorney staffing leads to our defenders having to refuse new cases? Well, those cases then go to our assigned counsel program. Right now, BIDS is paying our assigned counsel at a statutory rate of $80 per hour. The wording of our statute without some statutory amendment would currently prohibit BIDS from paying more than $80 per hour. A 2017 KBA study determined that the average per hour rate of private counsel in Kansas was approximately $225 per hour. That means that our $80 per hour rate is about 64% of the going market rate for private counsel in Kansas. The problem with the low hourly rate is that it makes it difficult to recruit enough assigned counsel to our panels in some areas, particularly in rural areas where attorneys have to drive long distances between district courts and county jails and their offices. And it also makes it difficult to recruit enough experienced assigned counsel to handle higher severity level cases. We field phone calls every week from judges looking for help finding attorneys to handle high severity level cases in their individual jurisdictions. It also incentivizes private counsel to take higher caseloads in order to cover their overhead costs and make ends meet. And it's been shown to incentivize private counsel to go to trial less frequently because the low rate of pay means that pleas are actually paid better for the time spent on them than jury trials are. Those pay issues, however, are not unique to our assigned counsel. They also plague our public defenders' offices. In spite of national standards that call for parity of resources between prosecutors and public defenders, our public defenders are consistently paid significantly less than their prosecutor counterparts with comparable experience. While starting salaries between prosecutors and public defenders start up relatively comparable, once each gains a little bit of experience, the prosecutor salaries quickly outpace our public defenders. A recent review of prosecutor salaries in Kansas recalled that when comparing our top paid public defenders in several cities where there are comparable prosecutors' offices, the top paid prosecutors were paid anywhere from 23% to 50% more than our top paid public defenders in those same areas. And that parity issue isn't even limited to a comparison between prosecutors and public defenders. It also extends to other comparable government defender salaries. For example, our top paid public defenders in the agency with 25 to 35 years of defense experience and as head supervisors of their individual offices make a salary comparable to what an assistant federal defender with 0 to 3 years of experience can make one down the block here in Topeka. It's no wonder that we have both a recruitment and a retention issue in our agency. If the caseloads were not enough to deter people from working for us, certainly our compensation issues would. These problems would be bad enough, but to add insult to injury, our agency is also severely under-resourced. Because our agency budget is so heavy on salaries and assigned counsel payments, we only have $682,170 per year for remaining agency operation expenses for 18 offices spread out across the state after rents are paid. We lack sufficient staffing in our public defender offices. For the entire state of Kansas, we have 123.5 public defenders, 23 legal assistants, 15 investigators, 25 administrative support staff, and 1 social worker. That's compared to 377 total county prosecutors that handle just criminal cases. We lack sufficient support staff in our administrative office as well. We operate our entire agency with only 8 full-time employees in our administrative office. We have no formal training division to provide the necessary ongoing training to our employees in our 350 plus assigned counsel. That's pretty unusual for most public defender programs. Even the public defender system in Missouri has a training program. We also lack basic infrastructure, frequently struggling to afford things like servers and phone equipment and computer equipment and legal resources. We still operate our assigned counsel program on a paper voucher system and do not have a modern case management system for our public defenders, all due to a lack of funding to afford these items. Of course, the impact of COVID-19 and the sudden need to remote work, appear for court remotely, and interact with clients remotely has only exacerbated our lack of resources in these areas. To solve these problems, we need a commitment from our partners in the criminal legal system, our prosecutors, our judges, the governor and the legislature to invest in our system. Investing in our system does have a variety of benefits. Private attorneys paid on a case-by-case basis, while a necessary and important part of our public defense system, really have little to no supervision by our agency. Rather, bids primarily foots the bill for those cases once they're done, with only a minor amount of control over those costs or the quality of representation along the way. Investing in an appropriately supported public defender's offices, however, as a main public defense system, creates structure that can help our defense attorneys meet their ethical obligations and ensure that they're following best practices. Public defenders have the necessary independence to make decisions about their client's representation, independent from pressure from the court. Public defenders are subjected to substantially more oversight, and staff are supervised for quality representation. Attorneys are not paid by the case, and so they're not incentivized to take more than they can reasonably and effectively handle. Attorneys and support staff work together as a team on cases, which not only provides better outcomes, but also uses an economy of scale that makes public defenders more cost effective. Staff can be trained and mentored in-house and provides a continuity of service throughout our state legal system. And public defender offices also act as a single point of contact in their jurisdiction, comparable to prosecutors' offices to address large court system issues and needs in a way that results in better justice system coordination. Finally, public defender offices also manage their own case assignments in-house, and when appropriately staffed, can be consistently available to the courts, alleviating much of the court administration's headaches of locating appropriate individual counsel in each case. Additionally, the research has shown that public defenders get better outcomes than individual private assigned counsel, including reduced case time for continuances, reduced likelihood of convictions, reduced likelihood of prison, reduced sentence lengths, and reduced potential prison costs. And so the question is, how can we here in Kansas do all of those things better? And the answer is through a holistic defense practice. We intend to move towards a more client-centered holistic defense model here in Kansas. For those of you who may be unfamiliar with the concept of holistic defense, here's basically what it is. It's an aggressive legal advocacy that recognizes that most poor people arrested and charged with crimes are struggling with myriad of other issues beyond just their criminal case, and that then further complicates their ability to navigate the appropriate outcome in their case and for them to continue to avoid additional contacts with the legal system. A recent report from the Brennan Center, for example, studied how imprisonment and lost earnings as a result of involvement with criminal legal system can further perpetuate inequality, and a client-centered holistic defense model helps to alleviate some of those issues. Holistic defense is also a proven way to cost-effectively meet our clients where they are in a way that provides significant benefits to our clients, the criminal legal system in general, and to do so in a way that doesn't endanger public safety. One of the things that I wanted to bring to all of your attention today is a recent 10-year study by the RAND Corporation. and the University of Pennsylvania School of Law of Holistic Defense Programs in the Bronx, in New York, found that holistic defense practices there were able to prevent more than 1 million days of incarceration. They were able to reduce the likelihood of a prison sentence by 16%. They were able to reduce the actual prison sentence lengths by 24%. They saved taxpayers an estimated $160 million in inmate housing costs. And in spite of higher pre and post-trial release rates, 10 years after case resolution, defendants in that study who received holistic representation committed no more crimes than those who were incarcerated for longer periods of time. In other words, holistic defense has been statistically proven to significantly reduce incarceration and save taxpayer dollars without harming public safety. That's why public defense systems from New York to Kentucky and Texas have all embraced the holistic defense model in their public defense systems. Kansas definitely can and should do that as well. However, in order for us to address our most dire and immediate problems with caseloads and staffing and pay issues, as well as to begin that transition to a client-centered holistic defense model, BIDS has made several necessary and fundamental budget requests in our fiscal year 2022 budget. Those budget requests are the first phase in a 3-phase plan that we recently shared with the Legislative Budget Committee that we've developed to begin transitioning into a holistic defense model. And those budget requests include $7.9 million for staff adjustments to address our ethically concerning caseloads, including 26 new public defender positions, 15 additional legal assistants, 35 additional investigators, 13 additional administrative assistants, and 6 additional administrative staff. That includes also $4 million for attorney and support staff pay parity compensation adjustments in order to correct some of those pay disparities that we discussed earlier. It also includes $164,025 for the establishment of a BIDS training division and the associated costs with that, as well as $3.5 million for an increase to our statutory rate from $80 to $100 an hour as the first phase in our 3-phase plan to increase our assigned counsel rate. That adjustment, however, also would depend on statutory amendments to amend that $80 an hour statutory cap. And also $347,141 for basic immediate infrastructure needs, including IT security items and a modern case management system. The chronic underfunding of public defense in Kansas, as I said, isn't just a BIDS problem. It's a criminal legal system problem. And everyone, defense counsel, defense clients, prosecutors, victims, police, and the courts all suffer the expensive consequences of it. That's why the fact that I mentioned at the beginning of this presentation is so important, that 85% of our adult criminal felonies cases in Kansas require appointed counsel. That's why that matters, because our entire criminal legal system really hinges on public defense being appropriately funded and resourced in order to function. And right now, it's not functioning. But starting with budget requests that we are making in our fiscal year 2022 budget, along with our 3-phase plan to convert our system to a client-centered holistic defense model, we believe that we can solve some of these problems in a way that is cost-effective and benefits the legal system as a whole. But to do so, we need a commitment from all of you, the other stakeholders in our criminal legal system, to support our efforts to sufficiently staff our caseloads, to make inroads in recruiting and retaining our employees, and providing appropriate support for both our public defenders and our assigned counsel. I know I kind of went through everything pretty quickly because I had a limited amount of time and I wanted to make sure you kind of had a good overview for what our situation is. But I do appreciate your time today and I am happy to answer any questions that you might have.
Heather, this is Mark Bennett. One quick question. Your first phase, I'm just looking for the total tally in terms of request for budget increase. What's the total for phase 1? Because if we want to include this, if we were to include in total what you're asking for, the recommendation would be to support what, how much of a specific request?
The specific total requested enhancements for fiscal year 2022 would end up totaling around $16 million. And that report, I provided both to our report that details that in far more detail than I went through in our presentation today. I did pass that report on to the staff for this commission, and it's also been passed on to the Legislative Budget Commission as well. So there's a lot more detail provided there.
Thank you. Yeah, Jordan gave it to everybody. It's for those of you who received it, it's entitled Report 9/30/2020. Thank you. Other questions for Heather?
Mr. Chair, this is John Francis, Washburn Law.
Yes.
Heather, thank you so much for this presentation. I think it was excellent. I think a lot of what Heather presented is an example of how maybe investing money up front will realize savings on the back end. And I think that's important for us to recognize it. And a lot of times these are proposals that appear to cost money, but I think it's really important to realize that there is a payoff on the back end, and that if everything works as planned, there will be an overall net gain economically. Heather, your discussion about the holistic approach, I think, is really important. I agree with you that there's evidence that there's a lot of benefit to that. You did mention at one point within the holistic approach, I think the words were comprehensive legal representation. What would that entail, or has that been fully fleshed out yet?
You know, for our purposes, in order to get started, it really boils down to sufficiently staffing our offices with the support staff that they need. I think in the past, because of budget cuts over the years, we've really erred on the side of cutting other support staff positions like investigators and legal assistants and social workers and things like that in favor of the attorneys, because you physically have to have an attorney in court with you. But that's a mistake, because then you're essentially paying the attorneys to do the investigative and the legal assistant work, all of which they're doing for attorneys' salaries. If they were appropriately staffed, that would alleviate some of those problems and make them far more cost effective than they currently can be when they're not able to handle their caseloads and they don't have appropriate staffing. Now, like further down the line, what that would look like would be something more along the lines of having assistance with some family law issues and immigration issues. Right now, we do have some immigration contacts that we contract with on some of those cases, but there's just a myriad of other issues that come up in the course of dealing with somebody's criminal defense when you're representing them as a person and not just as a case, that we could make better use of other resources in order to more effectively keep them out of the legal system again, or to reduce the time that they're spending in the legal system. And so our first line of defense is to staff our offices appropriately with some of the basics, but then beyond that, that is sort of what we would be looking towards moving towards in the future. And I appreciate your comments about it not, you know, it looks like it costs a lot of money up front, but one of the things that I didn't point out in my presentation was I looked at the cost of some of our wrongful conviction lawsuits. I mean, there's been 3 payouts in this state for $3.5 million, and that's just 3 cases. When BIDS handles 26,000 to, on a normal year, closer to 30,000 cases per year, it doesn't take a mathematician to figure out how quickly that kind of stuff can add up if you're talking about wrongful convictions and ineffective assistance of counsel claims and things like that due to lack of appropriate staffing.
Okay, thank you very much. And I really also want to kind of join in what Heather is saying about the importance of having proper investigative support and social work support with public defense. I think both of those are really indispensable.
Other questions for Heather? Well, if there's not, I'll add one comment. When Heather and I spoke about this in preparation for her comments today, I'll join Professor Francis, his comments as well. If I had to choose, frankly, I think social work is almost more important than investigators. I mean, the case gets investigated. There we are. Sorry, lost me there for a second. Cases get investigated, and obviously investigating, go in and find more people, et cetera. But in the vast majority of cases, what would really help a public defender is the social worker to help line up their client, a place to live. I mean, I can't tell you how many times I've said, look, I'm probation sounds great. I'm ready to do it. Just bring me a plan so that we're not just walking in empty handed to a judge. And, that's one of the real frustrations, I think, for public defenders is they know what we can all even be on the same page. We're just trying to get there because the person is without any means whatsoever to help themselves. So I say that only to point out that it sounds like social worker seems like a frivolous request. It's not at all. In fact, it would be among the most beneficial, I think. Last question I'd say, or last question for Heather, personally is, I think some of the disparity in pay and disparity in resources is, we can't forget that public defenders are paid for by the state. The prosecutors are paid by the individual jurisdictions. And so, a prosecutor can go to his or her local county commission and say, here's what I need. I'm here, come down to my office, see what I'm up to. And so the county commission can, it's very much more hands-on. Having a state-run public defender system obviously makes a lot of sense. And I'm not advocating for this, but in case someone were to ask this down the road, and if this is not a question you can answer in a minute or two, we won't unpack it right now. But the idea of having more localized funding streams for public defenders, I assume that model has been tried elsewhere, and having a state footprint, a state-run public defender system is, in fact, the best way to go, so long as it's fully and adequately funded.
Yes, and I will say that there are a lot of systems all over the United States that do use more localized funding, and the problem that you get with that is that you get exceedingly unequal treatment of criminal defendants throughout that, based on, obviously there are certain counties even within Kansas that can afford to put a lot more money towards a public defender's office if they were funding it locally than other counties. And so the problem is that you get into legal issues with the effectiveness of the system as a whole because of those disparities. So actually, having a statewide public defender system provided by general funds is sort of actually the gold standard, in that sense that we're actually where a lot of other systems would like to be on that. It's just a matter of then funding it appropriately. And I think you brought up a good point. It's a lot harder to make the argument to the funding source when it's the legislature about funding a statewide system, unless you do have, some of those more local contacts. And that's one of the reasons why in our report, if you notice towards the beginning of our report, one of the things that I specifically asked people reading the report to do is to go talk to their local prosecutors or their local judges about what happens when your local public defender does have to refuse cases. I used Salina and Topeka and Wichita as a good example. I mean, if you're in one of those areas, go talk to your local district court about what happens when the public defenders have to refuse cases and they are not available for appointments. It gets really difficult really fast to find enough attorneys to be able to handle high severity level cases and to be able to do so consistently when that happens. And so if you are a legislator or a community member, I would encourage that you do have those contacts so you can see a more local version of what that means in your area.
Okay, very good. Heather, thank you very much. Well, unless there's another question, we will thank you for your time. And again, I'd encourage everybody to go through the report. It's lengthy, but it's I think it's fair to say overdue for the public defender system. And I've told her that irrespective of what the commission does, at least in my capacity as DA, I'll do everything I can to help her out. It may seem counterintuitive that a DA would want to help the public defender, but it does me no good to have an inadequately staffed, funded, resourced public defender's office. We need to have somebody on the other side of the room that's putting up a fight, and that way we make sure everything's done appropriately and corners aren't cut, because while they have a high caseload, so do we, and it doesn't do anybody any good if they're not all operating on maximum efficiency. So,
Mark,
thank you much. Yeah,
this is Judge Brown. I just wanted to add, I worked as a contract lawyer for bids for years. I also served as a county attorney, and now I'm a judge. And so I've got I would hope a well-rounded perspective of what Heather was talking about. And I just wanted to join in your remarks. To have an effective criminal justice system, you've got to have experienced advocates on both sides of a case. And there's nothing more frustrating whether you're the prosecutor like your office or a judge sitting on the bench, to see a defendant who is not being properly represented due to whatever, whether it's a lawyer that doesn't have the experience or a lawyer who simply is going through the motions because the pay is so inadequate. The system suffers, and we all pay that price, every member of society. I would also, I think Heather would join in this. One of the other things that as a judge I look at is there's a regulation that puts a cap on each case that a private attorney is appointed to. And those caps are very low. In fact, those hourly rates drop down to probably minimum wage on some cases based on the cap, because the defendant, it may be a complex case, even if it's a low-level felony. And so that's another challenge. And then the judge is faced with a motion to declare it an extraordinary case so that the attorney can be compensated above the regulation. So if anybody has any questions about that, I'd encourage you to visit with Heather or your local judge, because that provides challenges as well. So I just want to join in Mark's comments that this is it's getting to a crisis level. And if we want to have a good criminal justice system, it's an extremely important component of that. That's all. Thank you.
Thank you. All right, very good. I appreciate those comments. And if there's nothing else, Heather, again, thank you. And at this time, we will turn it over. Took a little extra time, but it was time well spent. I believe this is an important issue. So we will turn it over to Patrick and the folks at the Center for State Governments. And Patrick, if you'll share your presentation with us, I'd appreciate it.
Thank you, Chairman Bennett. And Laura from our team is going to share her screen with folks so that you all can see the presentation that we're going to be speaking from. But I want to thank Heather for her presentation as well, and the commission members for that conversation. I think it's helpful for our team to hear more about how you all are thinking about exploring and trying to address those issues on that front. And thank you, Chairman Bennett and Vice Chair Owens, for allowing us this opportunity to present today. As usual, all the members of our team, we appreciate the commission overall for speaking with us and meeting with us to help us understand the challenges that you all are facing and thinking about how we can best help you all move forward. And as Laura has this presentation, we're going to go to slide 2 so we can show you the overview of our presentation slides that we're going to be covering today. And you'll see that we're going to first talk a little bit about justice reinvestment generally, then the current challenges, then the subcommittee updates, and lastly, move on to next steps. And we're going to skip straight down to slide number 6, actually, because that slide is where we get into some of the framing of how you all have been thinking about this conversation. The other slides are background about us and our organization that you guys will be familiar with. And if there are members of the public who have not yet had an opportunity to hear from us, those slides are in there for their benefit as well. And I forgot to mention, I think that I'm Patrick Armstrong with the Council of State Governments. I know that's part of what we're supposed to say when we start speaking. And so on this slide, you all will see that, or be reminded that obviously your criminal justice system is complicated. There's many different moving parts, and each of them require a pretty close examination. And you all form those subcommittees to focus on these 4 priority areas that we have listed here. And that is to prioritize prison space for those folks who are most dangerous, so you can manage that expensive part of your system. 2, work on increasing support for victims of crime. 3, strengthening community supervision so that you can change behavior and reduce revocations. And 4, focus on increasing access to treatment and employment and housing support to break the cycle of recidivism. Next slide, please. Next slide also. And this slide, you guys will recall from the last presentation, is a reminder that first and foremost, as a commission, you all are focused on keeping the citizens of Kansas safe and working on reducing recidivism. Everything that all of our team has been talking about with your colleagues in the state and in the subcommittees with you, they're really centered around those priorities. And in a system that is strapped for resources and has even more restrictions, and some of which Heather mentioned in her presentation a moment ago, but due to the pandemic that everyone has experienced in this country, the budget in your state is projected to have a pretty large deficit. And we talked about the importance of finding ways to efficiently use the limited resources at your disposal and try to prioritize any corrections resources or corrections investments in a way that effectively keeps Kansans safe. And even though recently there was some more positive news than you thought as related to the budget and the revenues coming into the state, you all know and we know that the deficit remains very large and it's going to be tough to overcome. So it becomes that much more important when you're thinking about how to use those resources. Next slide. You all will also recall when we last got to convene, we shared this prison projection slide, thanks to Scott Schultz and the Sentencing Commission for pulling those projections together. And as a reminder of the prison projections as of last year, and then also the projections more recently. And that bottom line on this graph shows that due to the pandemic, the prison population has decreased, and you'll see, though, it is gradually expected to continue rising. And that top line is the projections as of last year that came from Scott and his team that showed an even larger, steeper increase projected that would have required millions of dollars in constructions and operations costs that, frankly, would have been tough for Kansas to try to cover. So the good thing is there's been a little bit of relief thanks to the current situation, but we all know that once things return back to business as usual, as far as the state operating as it should and the backlogs get cleared out from the courts and law enforcement is able to use jail facilities as they have in the past, and that number here can possibly jump right back up, and Kansas might end up in a situation like they were in very recently last year, and this commission is working on trying to make sure that doesn't happen. Next slide. And what we shared was a reminder that it's going to be very important for this commission and the state overall to work on finding ways to improve the behavior of people in the criminal justice system and catch them a little bit early when they're messing up or if they're addicted to drugs, so that if their behavior can be changed early in the process, sort of along the lines of what Professor Francis mentioned a moment ago, if there's investments made, there's going to be some upfront costs, but when that type of foresight is had, then you can change behavior and reduce the need for incarceration later, and ultimately see savings later on down the road that you will not see if you don't invest early in the system. And part of that is making sure the prison system has the right folks in there, and people who are addicted to drugs or who are in for violations, technical violation of supervision. Those type of folks are maybe not best suited to be in your prison system holding up those expensive beds. And I'm going to turn it over now to Carl from our team, who's leading our sentencing assessment for our team, who's going to talk about how the prison system is currently used and how you all are dealing with those populations. Carl?
Thank you, Patrick. This is Carl Reynolds coming to you from Austin, Texas. Before I launch into this, I want to just mention something else about Heather's presentation. In the very fine print on Heather's presentation, you might have seen a reference to the Texas Indigent Defense Commission, which is an agency that I actually was involved in launching some years ago and was very involved with for the time that I was in the court system here in Texas. And since coming to the Justice Center, I have been involved in some evaluations of indigent defense, and those evaluations underscore some of the points that Heather was making about the value of providing adequate defense in terms of the outcomes of cases. If anyone's interested in some of that information, I can help you track it down. I also wanted to mention that the NLADA, the National Legal Aid and Defender Association, just a couple of weeks ago, issued a new report about the importance of defense counsel being assigned at first appearance when people are initially facing the consequences and often are not represented by counsel and enter pleas or otherwise have bad outcomes because they're not represented in that very first juncture in the system when they're in front of the judge. I can give a link to that report as well. In fact, I'm going to paste it in. I'm going to send it to Robin Crumpton because she's the person I'm able to send it to in case she wants to share it with anybody. But getting on to our presentation, this is a quick summary of some of the bullet points, some of the data points that we talked about in the previous meeting and that we've talked about with the subcommittee of proportionality and sentencing guidelines, focusing on the prevalence of people committing drug crime, both the prevalence in the upfront of the system, but also in terms of people showing up in prison. We showed a very colorful slide at one point that indicated that 27% of the people that were admitted to prison were coming in for drug offenses with no prior felony record. And the fact that the number of people in prison on hand for drug offenses has increased dramatically, 3 to 4 times more than other categories of people coming spending time in prison. And of course, women coming to prison and in prison, that proportion has more than doubled between 2010 and 2019. So a big sort of overlay between the gender issue that you all are facing and the drug problem that you're facing. And in terms of the geographical variation, one of the slides we showed you was an indication that there are some counties where in a system that overall tends to send more people to probation, there are a number of counties that tend to send more than half the people that come that are sentenced are sent to prison. And in the last year, over 400 people went to prison from just those counties that have more of a propensity to use prison than other places. Next slide, please. This slide illustrates the sort of deep end of the pool in prison. This is the biggest bars here on this bar graph are the off-grid sentences in 2019. There were only 87 of those sentences, but they averaged, arithmetic average, 24 years in length. So that means that 2,000 bed years of your prison space were spoken for last year by those 87 people on into the future. So that's all about prioritizing your prison space for people that commit incredibly serious aggravated crimes. So and then just to kind of give you an idea of what that part of your system takes, what it takes to house people that commit those kinds of crimes. Next slide, please. This is also about people in prison, and it's by the drug grid and the non-drug grid. Almost 1,000 people, 42% of people sentenced under the drug grid came in for level 5 drug offenses. So each color band on this graph is one of the levels in your 2 grids. So level 5 in the drug grid is by far the biggest volume. Interestingly, levels 1, 3, and 5 in the non-drug grid tend to be the ones that have a lot of volume for whatever reason. This also shows at the very bottom on the right in the brown shade, almost 1,300 people who are in prison for those off-grid offenses. I mentioned the 87 people sentenced last year. This is the on-hand population, so almost 1,300 people that are serving quite long sentences for off-grid crimes. Next slide, please. Rachel developed this nifty heat map. This is to show you, it's partly just to show you what you can do with the fact that you have sentencing grids. You can really look at them in an interesting way and see what's happening in your system in kind of a cool way. This is, Scott referred to it as a heat map, but this is showing you where the growth is, which grid cells on your two grids have the most growth over the last few years, 2015 to 2019. So this is showing the change in the number of felony sentences. The deeper the red, the more additional sentences were handed down in those cells. So this is regardless of the disposition. This is just pure number of sentences. And you'll see that there are boxes around drug grid level 5 and non-drug grid levels 6 through 8. So the next slide, Laura, shows you, kind of zooms in on those two boxes from the previous slide, and illustrates that in those high growth cells, those accounted for almost 1,400 felony sentences from 2015 to 2019. So not a clear policy implication of this, but it's, I think, a nice illustration of what you can do in terms of looking at your sentencing system and understanding where where the action is essentially. Next slide, please. Still focused on those high growth grid cells, this is an indication of what's driving the growth. And far and away, this is all about level 5 of the drug grid. It's, as you can see on the far left of this graph, the possession of drugs is the greatest volume driver in those high growth grid cells. A number of other reasons and relatively high volume in some other instances, but the drug offenses really jump out in this graph. Next slide, please. So you've seen this before, I think. This is based on average cost per day. Just people that are committing drug offenses, $41 million in Kansas to incarcerate those folks. Next slide, please. This is a repeat of a slide that we showed you a few weeks ago, but we wanted to really underscore this issue because in addition to drugs and in combination with drugs, a huge driver in your system, as in most states, is revocations from supervision. In Kansas, the majority of admissions to prison each year are for supervision condition violations, and that's what this graph is showing you year in and year out. The percentage of those people, the volume of those people that are coming into your prison system. Very tough problem to wrestle with. Your system relies heavily on supervision, and as a result, you have a lot of people under supervision and a lot of people getting revoked or getting otherwise sanctioned for misconduct under supervision. Next slide, please. This slide actually shows two different things. The major part of it, the colored part, is showing you the percentage of dispositions that went to prison versus probation in the big counties, basically. So total, state total, this is direct sentences, almost over 12,000 cases in that first band, and an overall tendency to sentence people to probation, 71% of cases overall being sentenced to probation. And I think, as I've said to you before, Kansas is a state that I have pointed to in talking to other states because your sentencing guidelines are solid, your system propels a lot of people to supervision, which is a good thing in general, as long as you have a really strong supervision system. And that first band illustrates how much that happens in Kansas. The other thing this slide is meant to illustrate is that there's a lot of variation even amongst these larger counties. And Douglas County kind of jumps out in this instance for having 41% of its cases sentenced to prison as opposed to the statewide average of 25. So Douglas County kind of leads the way among these big counties in terms of sentencing people to prison at the outset. Now on the right-hand side of this slide, there's just a column of numbers, and that is a look at probation revocation rate. And Douglas County has a 41% revocation rate, and Ford County is the highest on that list with 43%. Douglas County is the second highest. I want to pause for a second and tell you what we mean in this instance by revocation rate because it's a little confusing. Normally, if we, the Justice Center, were telling someone about a revocation rate, we would be talking about the percentage of people who were on probation or on supervision who got revoked. So maybe 10%, 10 to 15% would be kind of a normal number that you might expect. Another way of thinking about revocation rate is of all the people who terminated supervision, what was the percentage of people who were revoked of that group? Those are the two ways that people in our business normally describe a revocation rate. We were not able to provide either of those statistics with the data we had from Kansas. What this is showing you is that all of cases that were brought to court and styled as a potential revocation, the percentage of cases that ended in a revocation, as opposed to any other continuation or other outcome of that case. So it's a different sort of a look at revocation, one that's kind of unique to this project, again, because of data limitations. But the point is really to show you that there's a lot of variation in that rate from jurisdiction to jurisdiction. Next slide, please. So I think you've seen this before as well. This is again based on that $71.75 a day average cost to incarcerate people, just counting the people who were in prison because of a supervision violation. $43 million in the last year to incarcerate those folks. So again, this is all about that first bullet when Patrick started talking at the beginning, describing kind of the goals of this project and the goals that you set out in terms of prioritizing expensive prison space. We are stressing drug offenses and supervision violations as factors that you really need to look hard at in terms of that prioritization.
Hey, Carl?
Yes, sir. Yes, sir.
One quick question. This includes probation as well as parole in terms of the 43 million?
I believe it is, yeah. Any type of supervision violation. Next slide, please, Laura. Well, this is just sort of an admonition, and it's kind of the theme of justice reinvestment in general and of this project in Kansas in particular. And as Patrick said at the outset, we think that Kansas is facing a situation that that cries out for some changes. You're not going to be able to afford to do things as you have been doing them. You've got to do more to interrupt cycles of recidivism and get a better grip on your system. Even though you've got a pretty strong system to begin with, we're identifying in this presentation a number of ways in which that can be strengthened. Next slide, please. So on the right side of this slide, you'll see this list of 5 items that are it's kind of the purposes of the policy options that we have talked to the proportionality subcommittee about, as well as the sentencing commission. And I want to mention the sentencing commission here because we're still doing some work in anticipation of an October 22nd meeting of the sentencing commission. We're talking with Scott and his staff and working side by side with them to look at a number of sentencing policy options that we really want you all to take up and consider, and hopefully we can get all this done in time for that to happen. The point of those different policy options is to prioritize prison space for people convicted of the most serious crimes, expand diversion options available to prosecutors and judges, and that includes one of the ideas that you all have already been talking about. I think it's House Bill 2002, opening up treatment possibility for people who are in a diversion program. We're looking at the non-drug grid sentencing. Scott and his folks have been charged by the commission with looking at a proposal to amend the drug grid. And we are also looking at a parallel proposal around the non-drug grid, both of which are intended to look at what's happening now in your system and look at the tendency for there to be downward departures in your system and see if there are changes to the dispositional designation of different boxes in both grids that would better reflect what's actually happening now and also have the effect of promoting incrementally more sentences to supervision rather than probation. That's the basic theme of the ideas that are afoot. And then again, that we'll be talking with the commission about and we want to bring back to you as well. Number 4 on this list, making revocation sentencing more consistent and proportional. That is a really tough nut to crack. It has to do with the way that supervision officers work across your different supervision systems. It has to do with the way that judges respond and prosecutors respond, et cetera, to conduct relapses of people who are under supervision, and what can be done to make those responses more consistent and proportional to the severity of the conduct in question. And then finally, as I keep stressing, in a sentencing system that propels so many people to supervision, you've got to have a great supervision system to see success. And you have a good supervision system, and we're going to talk some more about how to make it great. There are 12 policy options under consideration by the Proportionality Guidelines Subcommittee. There's a whole other raft of policy options that the Supervision Committee Subcommittee is looking at, and we're going to talk to you about those today. But that's just a really key component of anything that Kansas does because of the nature of Kansas's system, and because it's a good system. It needs to be reinforced. Patrick, I think that's it for me. Does that sound right?
That sounds right. Thank you, Carl. This is Patrick Armstrong. Yes, sir.
This is Chief Akron. I got one question on the supporting the high quality effective supervision practices. and what the costs are from housing inmates, like say 71.75 a day or 742 out in supervision.
Right.
Is it in the numbers if we start bringing the people back out to the supervision? It's going to be obviously more than 742 in time, because you're going to have to hire a whole lot more staff. Supervisory staff is right now, I know a bunch of them that are so overflowed they can't even see all their clients that they need to see now. Do we know what kind of effect that's going to have? How much more staff they're going to need to hire?
I know
supervisory.
Right. I know that the Sentencing Commission has the capability to do projections of of impacts of changes, both on the prison system and on the supervision system. So yes, I think your commission will be able to tell you what they would expect will happen under various sentencing policy changes, both for the incarcerated population and the population under supervision.
Thank you, Carl.
Thank you.
Chairman Bennett.
Yes, Bill.
Hi, Bill Persinger here from Topeka at Vallejo Behavioral Healthcare. I had a question for Carl, and a really good job, everybody, so far today with the research and the numbers. In terms of, the cost of maintaining someone in the system who has a behavioral health problem, particularly a serious one, and some of the, the needs and the acting out. Is that, I heard a figure of $74. Can you restate that? And would that cover the cost of that subgroup of individuals who have a severe mental illness, for example, or, behaviors associated with former drug use, that kind of thing?
The $74 is an average cost per day in the Kansas prison system. So it doesn't specifically account for that. It presumably kind of accounts for it globally, but it doesn't depict the fact that a cheaper inmate is $60 and a tougher, more problematic inmate, an inmate with more needs might be a $90 a day inmate. But it's all washed together in that figure.
Thank you.
Back to you, Patrick.
Perfect. Thank you, Chief, and thank you, Bill, for the questions. We'll go ahead and move on to the next slide in this presentation. Patrick Armstrong with the Council of State Governments here again. We're going to now shift to speaking about those subcommittee updates, some of which Carl alluded to a moment ago, that what he covered was the proportionality subcommittee and what they're exploring, and now our assessment team from the other subcommittees are going to jump in and talk a little bit about what they've been working on with you all on up to this point. Next slide, please. And before doing that, just a reminder, we showed you a map like this last time. We all connected as well. Since then, we've been able to connect with even more of your colleagues and stakeholders across the states. Again, thanks to you all for making those connections. So now we've connected with people from 99 of the 105 counties and spoken with more than 180 people. And this is all basically in the last 3 months or so, since mid-July, when this all just got going. So thank you again for all of you for making sure that in the short, quick time span that you all have to get these recommendations together, you've given us access to a lot of your friends and colleagues across the state to pull information together for these subcommittees. Next slide. And as a reminder, our subcommittees work has covered a range of different topics to understand how the system is currently functioning. And that includes victims issues, violent crime, sentencing, supervision, behavioral health, and reentry topics. We understand that you all are under a pretty tight timeline pulling these recommendations together. So last week we had the benefit of connecting with each of the subcommittee members and presenting longer presentations with more detailed information, all of which you all should have received right before this meeting along with this presentation. So if you would like to get into more of the details of those, some of the items will be covered by the assessment team speaking from Council of State Governments today, and then also some of you all on the commission I know will probably have some comments on what you explored last week on these issues. Next slide, please. And so this slide is trying to capture that really with all the work that you all are doing across the subcommittees, there are some things that reoccurring issues that are, you can see when you're, whether you're looking at the supervision system, or the behavioral health system or the reentry system, no matter where you're looking, some of these overlapping themes or core practices can be improved across all of those. And we wanted to list those here because as you're reviewing the policy recommendations from our team and as we're talking about these, you'll see some of these themes show themselves multiple times. And so the 4 core practices that need to be strengthened or can be strengthened that we found with your subcommittee members are first, collecting better data and sharing that data. 2, leveraging existing resources. 3, formalizing multi-agency partnerships. And 4, training staff in best practices. And then these 4 things are broad categories that can, like I said, slot really into any of the sections and the need to improve them. And you guys will know this and remember from our conversations last week that they've come up in various ways and you'll hear them again momentarily. So I'd like to turn it over now to Jen Casella from our team, who's leading the supervision assessment, to talk about the work that subcommittee's been doing. Jen, is that okay?
Yeah, thank you, Patrick. Jennifer Casella from the Council of State Governments Justice Center. And with the supervision policies, we're really looking at strategies to improve public safety by reducing recidivism for folks who are on supervision, and really looked at things through the lens as well of budget and resources, and recognizing that resources are tight. Each of the agencies is facing budget challenges going into the next year, and finding ways to reduce inconsistencies as well as inefficiencies to be able to utilize the resources that you do have in a way that promotes success for people who are on supervision, especially those who are high risk and high need. You'll remember from the last presentation, if you go to the next slide, Laura, we looked at some folks who were on dual supervision in the state. And I think if we dig in on the client 2 example, which is the next slide, there's about 5 to 16% of the supervision population that is on dual supervision in the state, which equates to about 1,200 to 3,600 people across the state that are subject to, multiple supervision terms, and they're meeting with multiple supervision staff across different agencies. Some folks might be on triple supervision, some on 4 different supervision terms if you're looking at municipal probation, court services, community corrections, and the Department of Corrections. And so when you look at the dual supervision example that's listed here, you really start to see where there's some of those inconsistencies as well as inefficiencies in resources that are becoming challenges for not only the supervision agencies, but then also the success of people who are on supervision. So you'll see the LSIR risk score for the person is different based on the agency that did the assessment, which is the 3rd row over. If you continue to kind of move along there and take a look at office visits per month and field visits per month, you'll see that this person on supervision is meeting with 2 different supervision officers a total of 8 times per month. Those visits are typically during the daytime hours when staff work. That has been changed some in the last few months with different staff hours and the use of remote technology. However, this is typically done all during daytime hours. They're paying multiple supervision fees, one-time payments through community corrections, as well as $30 a month payments through the Department of Corrections. They're being drug tested between both agencies. There is not coordination and sharing of kind of resources and information across the agencies. You also have a full-time employment requirement for this person through community corrections, which can really be challenging if you're having to meet with a supervision officer 8 times per month. And you see those variations in conditions of supervision and special conditions. And so you're seeing kind of really this inefficient use of resources And when you're looking at conditions, some of them actually conflict with each other between the two agencies. In some areas of the state, there is consolidation of supervision terms. You tend to see this in some of the more rural areas where you might have a chief judge in a judicial district who's also on the community corrections board. They're seeing misdemeanor and felony cases. And so they're able to kind of make connections within their own jurisdictions to consolidate supervision terms. However, there's no mechanism across the state to consolidate those terms across jurisdictions. So across judicial districts or between the courts and the Department of Corrections. And so if you look at the next slide, there is sometimes can be unrealistic or conflicting excessive conditions of supervision that can contribute to failures, especially for those dual supervision cases. This slide is looking at the most common reasons cited for revocation at revocation hearings. You'll see the top 5 are failure to report, failure of a drug test, failure of a treatment program, failure to obey established rules, and failure to pay restitution and fines. I do want to note that this isn't the only reason that they were revoked, but this is the most cited reasons listed at revocation. I think in terms of the data system, what would probably be more impactful is knowing the highest severity violation at revocation. However, the data limitations didn't allow us to look at that. It was just giving kind of in totality each of the reasons identified. And so just being able to understand the reasons that folks are revoked and looking at our conditions and supervision standards set up in a way to promote success. So next slide.
One quick question there on the previous slide. I'm sorry. Does there, maybe you said this and I just missed it. I know you're trying to, you weren't able to say what like the severity level of the crimes were necessarily, but do we have any sense of, from the statistics you had available, how many, or I'm trying to way to put this that everybody will understand, but often in my experience, people have multiple revocation hearings, multiple revocation events. A judge says, okay, I revoke your probation, reinstate you. Don't do that again. You're going to get sent to the prison. And it's the second, third, sometimes fourth and fifth time they've had those events, those hearings before they're finally revoked on things. If I'm understanding, these are the final revocation event that got them sent out. Is there any way to track how many such events there might have been prior to that?
I know what you're talking about. Rachel, I know, Rachel, you're on the line in terms of the data. I'm not sure if this is the final revocation hearing where they're sent to prison or if this encapsulates each of those revocation hearings, even where someone might be sent back to supervision.
So this is Rachel Druckhammer speaking. Sorry, this is just based on all probation revocation hearings during the year. The way that I was able to get data, I couldn't get any information to identify specific people. So there wasn't a way really for me to trace how many times somebody had a hearing or what the ultimate outcome was. So that's why this chart is just looking at a snapshot in time, just the most common reasons that people were brought to a judge for a hearing. I was able to do analysis on just those that resulted in a revocation, but that is not shown on the slide. There's a lot of additional things we were able to do that we just couldn't really present given the time constraints today. But to answer your question, I was really only able to look at the final hearing that resulted in a revocation for that. I wasn't able to tell how many times people cycled through.
Well, I appreciate it. I didn't mean to sidetrack us, but I'm thinking in terms of policy changes down the road, that would be important to know because if judges are giving people lots and lots of chances, and then the final one is sort of the one that broke the camel's back, I think it's a different scenario in terms of how we ask judges to assess these things and hold off revoke somebody, et cetera. So anyway, again, didn't mean to cite, but I think that's an important equation in making policy change recommendations down the road.
Yep. Good point. Thank you, Chairman. So if we take a look at this slide, this is really looking at, kind of through our assessment work, there were varying perceptions that exist on how to balance punishment and behavior change, and really kind of what to do when there are violations and how to handle that. I know on Carl's slide earlier, he had shown 10 different counties, and you saw that revocation rate really varied between 19 to 43% in terms of the revocation rate for folks who were on supervision. And that really highlights those variations. In terms of the research and what the research shows in terms of incarceration, we know that pretrial detention more than 1 day increases failure rates, especially for low-risk individuals, and increases recidivism. You also have community sanctions versus jail sanctions for folks who are on supervision. And so when I talk with folks about punishment, a lot of times punishment is equated with jail and jail stays. And the research shows that other community-based sanction options other than jail have the same time to next violation, the same number of subsequent violations after the sanction, and the same likelihood of successful completion of supervision. And so it doesn't mean that jail sanctions aren't effective, it just means that there's limited utility. And so since they're expensive options, since they're also options that can kind of reduce some of the positive things that folks have going on in their lives in terms of maintaining employment, maintaining housing, that it's helpful to use them in strategic ways versus as a default option. We also know that prison has not shown to reduce recidivism, and the research tells us that punishment alone doesn't change behavior. It has to be done in conjunction with behavior change strategies and incentives for appropriate behavior. Next slide. In terms of diversion and diversion work, diversion is really an off-ramp from the criminal justice system to community engagement through case management, mental illness treatment, substance use treatment, housing, vocational, and educational services. And you see that happening at different points throughout the system, either before booking, through law enforcement. That can happen at the jail level, the pretrial level, or the court level. And there's some work with the diversion committee on looking at Senate Bill 123 and expanding some of those diversion options for folks so that they're able to receive that a little bit further upstream in terms of the system. So next slide. In the larger subcommittee with the diversion, specialty prisons, supervision, there were 2 policies that were passed out of that committee. Apologies that number 1 here is written a little off track. So this is to develop a statewide coordinated effort. This is for staff training, quality assurance, and continuous quality improvement. It was kind of misplaced on here around programming. And number 2, around an interagency re-engagement unit to target folks who are failing to report to supervision, on absconder status, or at risk of revocation, to be connected with resources to successfully re-engage them in supervision so that they're not violated. In terms of the work that the committee is working on and taking a look at, the next slide, there are approximately 10 additional policy options under consideration with that larger subcommittee for diversion, supervision, specialty courts. And it really stems around findings of improving supervision to meet best practice standards. This includes conditions of supervision, trying to address the dual supervision issues to consolidate supervision so that it can be more effective and efficient, as well as looking at variations in access and cost of programming, looking at information sharing across the agencies to reduce duplication and improve services, and address ongoing staff training challenges that do not occur currently across all supervision agencies and fidelity to practices. So the next slide is looking at some of those additional kind of challenges that the system is facing around those varying perceptions around punishment and behavior change, as well as data and uniformity and how data is collected across each supervision entity to allow easy system analysis, as well as for officers, for the supervision entities, and for the legislature to be able to make decisions around what needs to change and what's working well within the system. So I would like to, if you don't mind, Chairman, let Shelley Williams just talk for a minute about some of that ongoing work that the Supervision Committee is doing.
That makes sense.
To kind of move forward those policies.
Sure.
Okay.
Thank you, Mr. Chairman. Thank you, Jennifer. Can you hear me okay?
Yes.
Okay, great. Thank you. A couple of the items that we are continuing to explore ongoing within the next few weeks. As you know, resources vary across agencies and jurisdictions, and not all high risk and high need offenders are getting even remotely the same resources that others are in different areas of the state. And so we are looking at recommending to create an interagency work group to determine referrals and programming processes for people that are assessed at high risk and high need, and to look at it as a pilot project. And so sharing facilitators, sharing referrals, sharing different clients. So one of the things that we looked at is consistent programming is to be offered, even if a facilitator from one agency leaves their position, reduced workload for each agency facilitating the group, since there would be additional facilitators from other agencies, and then improved access to programming in rural locations through the use of video conference and technology. And having a dedicated facilitator or sufficient referrals is often a challenge. So we would want the work group to really look at what programming is available, to assess the capacity for delivering those services across multiple agencies, where the needs are in the state, and then developing that referral process. Another piece that we want to support is the work of the Sentencing Commission around earned compliance and early discharge from supervision. We didn't really want to duplicate those efforts, but did agree that we want to support the work of the Sentencing Commission around earned compliance. Standard conditions of supervision. Again, a work group that would have adequate representation from the courts, court services, Department of Corrections, community corrections, the prison review board, judges, prosecutors, defense attorneys, victim representatives, and someone with lived experience in the criminal justice system. And really just to look at what it looks like for a standard set of conditions of supervision. The recommendations hopefully from the work group would put forward for an appropriate oversight body for the 2022 legislative sessions to look at the statutory changes that may be needed if we were to have a group of that nature. And then of course, a rollout plan for the standardized conditions of probation. And lastly, what we are also looking at in the next few weeks is to how we really work on that concurrent supervision. Jennifer really highlighted the issues that persist with the multiple supervision entities and someone having multiple cases, whether it's in the same jurisdiction or across jurisdictions across the state. But just to really look at how we do that. And Ohio has implemented one recently, and we're taking a look at that and seeing if there are parts of that that could work for Kansas in moving forward with the consolidation of concurrent supervision. So those are the things that we're still working on and have a time frame, I know, before October 26th to get that to the larger group. So thanks, Jennifer.
Yeah, thank you, Shelley. There's been a lot of kind of work and effort put into kind of the policies and the policy development and really thoughtfully examining kind of what would work best in Kansas and make the most sense in terms of the system. So some great work that they are doing out of there. And so next up we have behavioral health. And so barring anything else, I will turn it over to Sarah Wurzberg.
Thank you, Jen. This is Sarah Wurzberg from the Council of State Governments Justice Center. Next slide, please. So nationally, the rates of mental illness and substance use disorder in the justice system are significantly higher than the general adult population, and effective treatment really depends on addressing both criminogenic risk and behavioral health needs simultaneously. So what we see here is most of the prison admissions for drug offenses are medium to high on the level of service inventory revised, or the LSIR, which is the criminogenic risk and needs assessment tool used by Kansas Department of Corrections, or KDOC. And about 60% of admissions for new nonviolent offenses and half of admissions for new violent offenses scored moderate to high on the LSIR domain for alcohol and drugs, indicating that they might be in need in some type of intervention or treatment. Next slide, please. The next slide is actually from the legislative post-audits, which looked at mental health in the local jails. And almost all the counties offered some level of mental health services, such as medication or identification of suicidal inmates. There was less so on screening and evaluation, and less than half jails indicated that there was mental health training, and about a quarter of the jails had discharge planning. And of note within this was that typically the larger jails were able to offer more services than some of the smaller jails. Another thing to note too on the prison side is that about a quarter of people released from prison each year have mental health needs that are requiring some level of treatment or services. So for the Mental Health and Substance Abuse Subcommittee, we were able to present some initial findings, and the subcommittee actually has not voted on it. So I'll be able to talk in broader strokes about some of the conversation and the discussion that has happened in that subcommittee. But first, I wanted to offer Bill Persinger, who's a subcommittee member and the CEO for Vallejo Behavioral Health, an opportunity to give some introductory remarks.
Chairman, this is Bill Persinger at Vallejo in Topeka. Thank you, Sarah and Patrick, for all your work and support. And so I think I'll just restrict my remarks to some general things and kind of give just a broad perspective of where we're at as we work towards our end of the report. In terms of the programming and the ideas and the conversation, sort of the look and the feel of our subcommittee conversations so far, led by Representative Owens. My perception is that we're really focusing on some big areas, working upstream, prevention, early intervention, jail diversion, a greater connectedness between law enforcement and corrections, the courts and behavioral health providers. We want to look at programs and processes that are available before, during, and after incarceration, and even more importantly, processes, policies, programs that divert people where appropriate from a jailing. We want to really focus on programs that are scalable, because we know things are different in all 105 counties. And I will say that, in the way I'm looking at things, a lot of the programs, the services, the interventions are not necessarily based on new buildings and new construction, that kind of thing, more based on people interacting with other people and having more of those folks available. So we want to really take a look at best practices, kind of a cognitive approaches that make sense out on the street, and approaches that are pretty hands-on, but also cognitively based and somewhat structured if in certain situations. We know that I spent quite a bit of time talking about the impact of methamphetamine addiction and abuse on our system, and alcohol abuse, and you put the two of those together and you have quite a bit of of the source of behavior that might draw people to the attention of the authorities. So addressing those problems is very important. Housing and employment, particularly not only as diversions and resources that will help people stay out of jail, but when people are leaving incarceration, do they have a job? Do they have a place to live? With those two stabilizing factors, you can reduce quite a bit of risk of reoffending. And I might point out here too, it's becoming even more clear to me, and I might be the last one to get this. Maybe you all are already there, but it looks to me like there are parallels in the field of criminal justice out there in the field of public education, healthcare, community healthcare, other professions, where we're finding that behavioral health makes a contribution in helping address the motivational and the emotional aspects of various kinds of programs. So you take a look at probation and parole, you take a look at needs behind the wall, you take a look at what's going on with families. When we bring mental health into the picture, what we can offer other disciplines, probation, parole, education, healthcare workers, is that element of understanding and intervening in a way that addresses the emotional and behavioral and the motivational factors. So an individual, doesn't comply with parole and probationary standards and requirements, may get down to motivation, emotion, and the emotional aspects of that particular behavior. So I think that's important to know that, the field of criminal justice is coming right along and maybe even leading the way when you look at public health, public education, and healthcare. So we take a look at community-based programs, and how maybe they can have an effect on behavioral health programs, how they can have an effect on probation and parole, and increasing compliance there and creating other diversions. We've talked too about Senate Bill 123. We've talked about drug courts and mental health courts as a way of increasing accountability and helping address that issue of what are the emotions, what are the motivations that are contributing to or getting in the way of an individual's compliance and their recovery. So I might just stop there. That's the general nature of what we're talking about. Best practices, scalability, cognitive-based programs and interventions, and then what can behavioral health providers bring to the profession of criminal justice at all levels. So, Sarah, if that's enough of a summary, I'll stop there. I've appreciated all your work as well as Patrick's and our chairman, Representative Owens.
Thank you so much. That's great and very helpful. A very comprehensive overview of some of the discussions, and I'll try to add a little bit more detail as well. Appreciate it.
Thank you.
So this is Sarah Wurzburg for the Council of State Governments Justice Center again. Next slide, please, and actually skip to the next one. Thank you. So what a lot of, as Mr. Persinger discussed, a lot of what we're talking about is connections to community-based mental illness and substance use disorder treatment, and really making sure that if people receive services in a correctional facility, they have a direct, ideally warm handoff, or at least information is shared to the community mental health centers or the community-based substance use treatment provider to make sure that there's coordination of care for those people as they re-enter the community. That also includes additional coordination with community supervision agents to make sure that they are coordinated with the reentry planning processes, particularly for people who have mental illness and substance use disorder treatment as conditions of release. There's also some increased need for co-occurring mental illness and substance use disorder treatment within the prison systems and correctional facilities generally. Next slide, please. One of the big topics that the subcommittee was able to discuss was actually the use of telehealth services and the real opportunity for telehealth to be expanded to support people in correctional facilities. So making sure that there could be additional opportunities for community-based providers to connect with people while they're in jails and prisons to help with that reentry and diversion processes. There is also discussion of opportunities for different types of positions, such as correctional facility liaisons, that would help support having a point of contact for when people are in jails or prisons, so that the Kansas Department of Corrections or local jails would know who at the local provider system they could connect with. There's a lot of talk of pre-arrest diversion options, such as mobile crisis teams or law enforcement responses. Also, the ability to consider pre-filing prosecutorial diversion opportunities for people with substance use disorders. There's also discussion on thinking through more ways to standardize some data collection, so there would be more accurate data on people with mental illnesses and substance use disorders in the justice system, not just now through a report, but across the years to come as well. There's also much discussion on the need for additional training for both people within the community-based behavioral health system to be able to get more information on working with people in the justice system, as well as training for community supervision and corrections on mental illness and substance use disorder, since it's such a large intersection. Next slide, please. And so I am going to turn over the presentation to Erica Nelson.
Thank you, Sarah. Erica Nelson with the Counsel State Government's Justice Center. I think Mr. Persinger said it just right when he said about this intersection of various fields like behavioral health, housing, employment, and education. What we know is, in terms of reentry, that is not a program, it's an actual process. And what research shows is that connecting a person to the right combination of supportive systems, housing services, treatment, appropriate intensity of supervision, education, and employment services during various points within the reentry continuum can reduce a person's chance of reoffending. Next slide. So we took a look at KDOC data, and with regards to new offense admissions, there was about 2,500 in fiscal year 2019, and 57% of people were assessed as medium to high risk to reoffend. So if you're looking at this chart, it's the fourth bar from your left. And of those persons, 98% had a moderate to very high need with regards to education and employment, according to the LSIR. So majority of your population, just like what Sarah said, is moderate to high, but then we also know that those out of that group, a large proportion also have a high need with regards to education and employment. Next slide. For the most part, KDOC is prioritizing education and employment for people with an indicated need. However, the agency is unable to meet the demand. So about 2,000 people released in fiscal year 2019 assessed as having a moderate to very high educational employment need, but only about 633 or 31% were enrolled in education and employment programming prior to their release. So in this chart, it does have a breakdown by the type of commitment. And then if you look at the top of the chart, the numbers across shows the actual amount of people who were assessed at that level. And then the percentages, which are colored in, shows the amount of people within that group that was actually enrolled in programming. Next slide. So there's numerous reasons why a person was unable to receive education and employment services prior to their release. It could be because of a short sentence. It could be for financial or the need to self-pay. operational procedures within KDOC that may inhibit the amount of programming that's offered each day. But last week, we put forth about 19 policy recommendations that focus on increasing access to reentry, education, and employment services, as well as employment opportunities. And I'll share the last 6 recommendations are kind of a package deal, which I'll have my colleague Josh Gaines speak to. But basically, these recommendations supported for fully opting out of the federal ban on SNAP and TANF or both by repealing existing restrictions in Kansas law that prohibit benefit eligibility based on felony drug convictions. So as of right now, in Kansas law, when we take a look at those who would qualify for SNAP benefits, it actually excludes folks with a felony drug conviction, with just one felony drug conviction, and any sequential convictions can result into a lifetime ban. And for TANF, it's just a little bit different with regards to that, but the breakdown is in the full presentation, which we shared prior to this meeting. Another recommendation we actually took a look at was sustainability for the Second Chance Pell pilot programs. As of right now, KDOC received opportunity to participate in this pilot program, which would increase education and vocational programming for those who are in the facilities. One of the things we talked about is this is a great opportunity. I believe about 7 colleges are participating, and it will increase the amount of people who can actually receive programming. But this is a pilot program. It won't last forever. So conversations have been put in place about, you know, how do you leverage existing partnerships within the colleges to secure funding and resources to further out, provide more programming. Another is in talking with providers of education programming, the colleges as well as businesses, what we learned is there's a lot of programming that's happening that's equipping people with the skills that are needed for employment opportunities. But in terms of businesses knowing what's actually available and how they can meet the demand of the businesses, that may not always be the case. So we talked a bit about developing a marketing plan for KDOC vocational career technical education to businesses and legislators to show that KDOC untapped skill population has what it takes to meet the need of businesses, as well as that Kansas stakeholders should continue to invest in programming. Next slide. Another recommendation we had was around the Workforce Innovations Opportunity Act, one of which is a very large funding stream within the state that supports education and employment services and training. As of right now, there is not representation from KDOC on the Kansas Work State Board, which develops the WIOA state plan. We shared the importance of having representation on that state board to ensure that people who are in the justice system, that their needs and supportive services are communicated and brought in within that plan in a way that's effective for the population. So again, 19 recommendations, but I want to turn it over to my colleague, Josh Gaines, to share a little bit about what we introduced with regards to occupational licensing and those last 6 recommendations that is on this presentation deck. So next slide.
Thanks, Erica. If we can go advance one more. Excellent. Yeah, so one of the barriers to employment that's significant and can be addressed without much cost through statutory reform are barriers to occupational and professional licenses that are triggered by a criminal conviction. We did a significant policy dive into sort of the landscape there in Kansas and found that for the most part, all of the professional and occupational licensing boards in the state have broad discretion to deny people with felony convictions any occupational professional licensure at all. And we're not talking about, just doctors and lawyers and that sort of thing. Skincare specialists, EMTs, pretty much any work in the healthcare industry at any level, cosmetologists, all of these sorts of things. So it's a pretty big group of the workforce. In fact, 1 in 5 people in Kansas are employed currently in licensed or certified jobs. As I mentioned, the healthcare industry, one of the fastest growing, one of the greatest industries as far as opportunities for advancement and income stability goes, is a pretty big part of that. So we looked at that law, 2018. The legislature enacted some limitations on that, that took some important steps forward. But there's still a long way to go before the state really aligns with national best practices related to consideration of criminal history in occupational licensing. So one of the recommendations that we've made is to really bring Kansas up to speed in that area. A lot of this is about ensuring consistent, accountable application of criminal history disqualifications for licensure. This includes giving people individualized consideration governed by a number of very specific factors, such as time since conviction, all of these sorts of things. Eliminating or narrowly tailoring existing exemptions to the current protections under the licensing law. Currently, most healthcare providers, most healthcare licensing agencies, and any license that requires a bachelor's degree or higher has no protections at all. We were actually lucky enough to connect with the Board of Cosmetology, who has implemented most of the recommendations here already as a matter of their policy without any statutory oversight. We found that it was pretty low cost, especially in the long term, and very much so in the short term as well. And then it's worked out very well for them. So we're recommending, because the regulatory structure of licensing boards in Kansas is so dispersed, to make statutory changes that would really implement most of what this particular board is already doing and having success with. Erica?
Thank you, Josh. So that wraps up the education and employment piece. I'll turn it over to Sarah to speak a little bit about housing.
Thank you, Erica. This is Sarah Worsberg from the Council State Governments. Next slide, please. So of the 11 million people admitted to jail annually, about 15% report experiencing homelessness the year prior to arrest. And for people with behavioral health symptoms, they're about 1.5 times more likely to experience homelessness than other people incarcerated. Next slide. And so Kansas Department of Corrections has indicated that 20% of people who are leaving their KDOC facilities each year do not have stable housing. And something to note is that in Kansas, there is a low housing stock overall, and it can be challenging for people to find housing, particularly in rural and frontier areas. And this has led to some innovations in the state for state and local agencies leaders, but these challenges for anyone and then are often much even greater barriers for people who are in the justice system or who have criminal records. Next slide, please. So there are 11 policy options that we discussed and were passed through the subcommittee, and I'm going to briefly go over some of the higher level points to it. So there's really opportunities to leverage some current efforts underway to address the housing needs for people of Kansas, and really to think through how to include people in the justice systems as part of these larger conversations. Really thinking through how to identify, discuss additional barriers for people who have criminal records or in the justice system. One option is through the Lieutenant Governor's Rural Prosperities Task Force. There's a housing component of it, and the Kansas Housing Resources Corporation is working to develop a statewide housing survey, which is the first of its kind since the 1990s. So one option is to try to get people in the justice system as part of this survey and as part of the conversation also in the Housing and Homeless Subcommittee. Next slide, please. There are opportunities to increase coordination between state level agencies, so KDOC, Kansas Housing Resource Corporation, and the Kansas Department of Disabilities, Aging and Disability Services, or KDADS, to make sure that there's formal ways for these agencies to work together and to think through how to leverage some of the current efforts that are already underway through the balance of state continuum of care, which is the majority, 100 counties in the state, which have regional coordinators, and the housing management information system through the balance of state as well. Next slide, please. There's also an opportunity to identify statutory and administrative restrictions on housing for people with criminal histories, and really to try to distill what the actual perceived barriers are versus which restrictions are mandatory. There was some misperceptions on what type of housing people in the justice system might be eligible for. So really getting to the specifics of what people are eligible for and why. There's also the need just to identify people in jails and in prison who have housing stability or at risk of homelessness, so there can be an appropriate response. Next slide. There's also the opportunity to utilize justice system partnerships to provide training for housing providers on working with people in the justice system, including information on criminogenic risk factors and common misconceptions that there may be to working with people in the justice system. Next slide. Then on the flip side, additional training for community supervision officers on housing opportunities, how the housing system generally, and how they can better coordinate with continuums of care, housing authorities, landlords, community mental health centers, and other housing support service providers. So that is the end of the commission. That is the end of the housing piece, and I will pass it to my colleague Laura to discuss victims.
Great. Thank you very much, Sarah. This is Laura Vanderlucht from the Council State Government's Justice Center. And the next set of slides, both for their victim-focused assessment and for the violent crime assessment, is information that has been provided to the Sentencing and Proportionality Guidelines Subcommittee. And so certainly, while we're giving the highlights here, there is much more information that went into these assessments as well. So from our victim assessment, statewide crime victimization surveys help states to understand the full scope of victimization in a state, and they also allow leaders to identify vulnerable victim populations that systems aren't currently serving or who may be going underserved. And so state victimization surveys are modeled after the national crime victimization that's been fielded for decades by the Bureau of Justice Assistance, and really help states to understand victimization from the perspective of victims themselves. And with that knowledge, states are better equipped to create specialized funding and resources that meet the needs of victims, and especially those from marginalized and underserved victim populations. So for example, when Wyoming conducted a statewide victimization survey in 2011, it found that in the immediate aftermath of a crime, talking to mental health professionals was the most utilized resource by victims. And this helped Wyoming to make service delivery more efficient for victims in the state. And then more recently, Missouri's statewide victimization survey found that emotional abuse was the most common type of abuse experienced by victims. And this finding gave direction to a public education campaign about support services that were available to victims of crime. And so the subcommittee members are thinking about how to utilize tools like statewide victimization surveys in conjunction with statewide needs assessments that are already being conducted by the Kansas Governor's Grants Program, or KGGP, to understand the full range of victims' needs across the state. And they're also thinking about how to bolster and strengthen existing crime victim resources like victim witness coordinators who provide critical assistance to victims as they participate in the criminal justice system. And so as Kansas is considering changes to systems that respond to the risk and needs of people who commit crime, it is important that state decision makers also make commensurate efforts to repair the harm that has been done to crime victims and people who have experienced victimization. And so I'm going to move into talking about our violent crime assessment findings. And just an important note that our victim-focused assessment and our violent crime assessment really were approached as part of the same phenomenon or two sides of the same coin. And so as a result, the following overview highlights from our violent crime assessment also keep the needs of victims and survivors at the forefront of our assessment. So reported violent crime has been increasing statewide since 2013, driven by increases in aggravated assaults and aggravated batteries. And as the map on this slide demonstrates, the largest proportion of reported crime occurs in Kansas's population centers. It's important to emphasize that this increase is in reported crime, those crimes that police observed or that were reported to them in the FBI's Uniform Crime Report or UCR violent crime categories. The Kansas Bureau of Investigation, or KBI, is supporting law enforcement agencies per its mandate statewide to transition to incident-based reporting, but current pressures on the state budget have delayed the implementation timeline. And meanwhile, despite best efforts by law enforcement at collaborative cross-jurisdictional investigation, without this incident level data, it's hard to track incidents of violent crime and most specifically domestic violence statewide. So while the majority of reported violent crime occurs in population centers in Kansas, rural and frontier areas have also had increases in reported serious violent crime. And while you can see that these increases are not large in number, the experience of the increases really looms large in these smaller communities. And for example, small police departments with 5 to 10 people in staff are the norm and not the exception in Kansas. And for these departments, responding to more serious and more frequent violent crimes truly taxes their resources and time that's available. And also, more integrated social fabric in smaller communities often means that the entire community really feels more personally impacted by serious criminal events. And then underlying the increase in aggravated assaults and aggravated batteries in recent years is a pattern of domestic violence across the state. And law enforcement and victim advocacy agencies that we spoke to as part of our assessment statewide report that in recent months in particular, serious domestic violence calls for service have increased, as has the severity of the violence that is being seen in these calls. And some jurisdictions are even reporting double and triple the number of calls for service over those of the same time last year. Additionally, resources for addressing the behavior of people who commit domestic violence is inconsistent across the state, despite the existence of statewide standards. And this is most notable in the availability and use of batterer intervention programming. And BIP is implemented inconsistently statewide, despite standards for assessment and for program curriculum. So the committee members in the Proportionality and Guidelines Subcommittee are considering 8 policy options that address violent crime in Kansas and can be characterized by 2 overarching policy priorities. First, understanding violent crime in Kansas at the incident level to improve investigation and to help build community trust. And second, holding people who commit crime accountable and to ensure that they receive the interventions needed to change their behavior and not reoffend. So in closing, improving data collection and data transparency, holding people accountable for the harm they perpetrate, and strengthening local coordinated case response capabilities can help Kansas to accomplish 4 things. 1, stop first-time offenses. 2, reduce recidivism. 3, repair harm. And 4, to build trust. And these are the 4 components of a public safety strategy designed to address violent crime statewide. So with that, I will turn it back over to Patrick.
Thank you, Laura, and thanks, team, for going through that, and to the commission members for stepping in with feedback. I'll be brief here because I know you all as a commission have a few other things you want to get to likely. And we can go to the next slide, please. and just remind folks on the timeline that we are working with you all over the next few weeks to make sure that we reach your October 26th deadline for finalizing policy options that can go into your report. So however we can support the subcommittees, we'll continue to do that, but we'll also keep an eye out for questions, feedback, anything else you all might be able to need from us in that time span, in the hopes that by November, early November, you have what you need from us to move forward in a productive way. But thanks, team, and Chairman Bennett. We can open it for questions if you like, or we can we can adjust however you need to according to the schedule that you all need. But thanks for your time from our team.
Thank you, Patrick. I'll open it up for questions for Patrick. Okay. Well, thank you very much for all the work. I would say on behalf of the commission and all the various members of the various subcommittees, your work is going to make our work infinitely much easier. I think identifying issues, things that we all knew intuitively, are helpful, but or rather knowing it is one thing, but being able to quantify it, being able to have the numbers to back it up, makes it a much easier sell, not only in terms of identifying what we need to recommend, but also in making that pitch to the legislature later that this is truly a priority, this or whichever items we settle on. But so thank you very much for the effort. It's going to help us a lot. All right. Well, if I managed to shut my oh, here we are. So I managed a moment ago to shut my PDF of the agenda, but we are at 3:36. We're a little over time, but why don't we go ahead and take about a 10-minute break right now, give everybody a moment. We've been at this for over 2 hours, and let's come back at 10 till. I guess that's 14-minute break. Let's come back at 10 till, and we'll have updates from the various subcommittees. I think obviously a lion's share of what the subcommittees have been talking about is been at least addressed, if not covered, but I'd like to hear from the chair of each of the various subcommittees when we come back, and we'll finish up with some discussions again about our goals for the final report in December, but I think we're making good progress. So we'll go ahead and take a break. It is 3:37 by my clock. We'll break till, like I said, 10 till, so 3:50. Talk to you all shortly. All right. Everybody back? It is now 10 of, so we'll go ahead and get started again. Spence, I hope you're on. I think you happen to be the first on the list here for the update for the Diversion Specialty Courts Specialty Prison Supervision Subcommittee. So Spence Cohen, if you could give us an update.
This is Spence Cohen with OJA. So our subcommittee met, on the 7th, and Patrick and Jennifer gave their review, a lot of what they presented today. So I think they covered most of what's going on with our subcommittee. If any of the chair people of the work groups wants to speak up and say something different, they're welcome to. But I know Shelley gave an update of what's going on already today with the supervision work group and what they're continuing to work on. We did pass or vote on as a group on a couple different recommendations that will be passed on to the full commission for the report, including Judge Brown brought forward a specialty courts recommendation that was crafted, and that was voted on, and we'll pass that on. We'd already passed on or voted on the specialty prisons recommendations. The diversion group is finalizing their recommendations, and I should get those soon, I suspect, and then we will meet. I believe next Friday will likely be the date that we meet to pass that and what else the supervision work group works on. So I think that does it for our group, unless there's one of the chair people of the committee work groups wants to add anything. But otherwise, I think that's what we're doing.
The diversion working group, you're right, we're real close. I actually have a rough draft. I was just waiting on final comments from some of the members, but we'll have that to you probably tomorrow. And I think that'll finish up the work of the working groups within this subcommittee. Any other questions for Spence? Okay, thank you. All right, mental health, Chairperson Owens. Mental health substance abuse.
Thank you, Chairman Bennett. I don't have a whole lot to add. I think that our friends from CSG did a great job. As they mentioned, we have about 20 plus proposals. We will be meeting a week from Wednesday to narrow those down and vote on what we want on the final report to ensure that we meet the deadline. So I certainly want to take a minute to express my appreciation for them and their work. They have been just top-notch individuals to work with and have added an incredible value to our subcommittee and the committee as a whole. So thank you to Patrick and Sarah and all the rest of the CSG team for the work that they've done. But I expect a full report with recommendations from our subcommittee here in about 2 weeks.
Very good. Any questions for Representative Owens?
Mr. Chairman, it's Todd. Some of these questions that I have, Bill Carr sent me because he could not be here today, and I would concur with him on some of them here. Professor Francis, on these, let's see, the draft that was sent out to us. The recommendation, legislature amend the severity level, personal drug use, possession charge from felony to misdemeanor. What are we going to do about staffing? The recommendation that a co-responder program be implemented. Who's going to pay for this thing? Not that it's a bad thing, but our departments, we're taxed the way it is. There's no way that we could add more staff that I know personally that I'm not putting bodies in cars patrolling. I don't know if that's been a consideration or if there's anything done on that yet.
Mr. Chair, this is John Francis. So with the idea of the co-responder program, that was a discussion that came up in the subcommittee. And not to pass the buck, but Bill Persinger actually has much more insight on this than I do. and so to me, it sounded like a great idea. And some of what we talked about in the subcommittee was that Again, this is another situation where it might be an outlay of money at the front end that will yield savings on the back end. One of the issues that we saw that was coming up, at least in the context of Shawnee County, and I'm going to pass it to Bill in a moment, but that the incidence of jailable arrests went down when there were co-responders with police on certain types of calls. I think the mechanics of it might get to be a little more challenging in the smaller jurisdictions, geographically smaller. But I think that there's an opportunity here to kind of steer the direction at the front end, which will yield savings on the back end. But Bill, can I toss this to you to put a little more flesh on the bone?
Yeah, Bill Persinger is currently unavailable. No. Chairman Bennett, this is Bill Persinger in Topeka, and Chief, having spent the bulk of my career up working in and around the 22nd and the 2nd Judicial District, I understand the challenges up there. Many a night, out at 2 a.m. working with law enforcement on cases, and I don't think that a co-responder or a crisis intervention team approach in Marshall County, works the same way it does in Lyon County or Johnson County or, Seward. And, but, in terms of scaling that to a region or a group of counties, it is possible with increased mental health assets after hours, licensed personnel or peer support workers or case managers who can be on call to assist law enforcement in various and sundry ways. It doesn't necessarily mean, riding in a patrol car, dealing with people as you see them, because I think more in a rural area and even some of the more dense rural areas where we're not going to see, maybe the unsheltered homeless at risk, obvious to, a law enforcement officer or someone out on the street, going to probably respond more on a case-by-case basis. And it becomes a matter of personnel and communications. How quickly can we get a mental health professional or a paraprofessional on site to help a law enforcement officer? And backing up from that, what training can we provide to our smaller or medium-sized law enforcement offices for those professionals that will help them, discern and ascertain when to call in that asset? A week of crisis intervention training is probably not, doable in some departments, given the cost of training and personnel and the smaller departments that are out there. But is there mental health first aid? Are there in-services that could be provided? How can we scale that? And I think it's an important tool to give our law enforcement officers, regardless what city or county they work in. It's just a matter of how we're going to get that done. But I had every intention of trying to scale that to the smaller to medium-sized departments. I know when I was in Lyon County in the 5th District and some of that area down there, the 14th and 13th, we had a real difficulty, keeping up a CIT program, but we did put a couple of smaller assets in place. One of those being the mental health liaison to local law enforcement, which, in some areas might be a half-time person, other areas could be 3 or 4 people, but just having someone to visit with in real time who can add that behavioral element, to the conditions that law enforcement officers find themselves in every day. There's a way to do that in rural and medium-sized areas. And that principle of scalability that we mentioned several times is very important to me. I've worked everywhere from Kiowa County to Shawnee County, so have a real, heart and feeling for what law enforcement does out there, and would put in everything I can think of to make that scalable. Bring an asset to jurisdictions like yours, Chief.
And this is Todd Ackerman again. Because like in the last week alone, I have 4 attempted suicides at night, 2 being juvenile, 2 being adult.
Yep.
And then I'm tying officers up sitting in hospitals because I can't even get them screened for almost 12 hours. That's unacceptable. If you want to talk about mental health, we got a long way. We got to start training like emergency room personnel and doctors and nurses more than we are as well. I shouldn't have to take somebody off the street and set them there and babysit somebody in the hospital. They definitely have to be there or we wouldn't have put them in custody, Yeah. And it's a very unfortunate, it's a huge issue in this country, but I would agree that we need training, the CIT training. Any responsible agency, no matter what your size. You know, I have 8 full-time guys. I can tell you, we're already starting a CIT program. You know, we see it coming down federally. We're just trying to get ahead of the ball here. And I think if you're an administrator, you should, or you're being irresponsible.
I also wanted to make sure, Chief Ackerman, this is Stephen Owens, that as we discuss these issues on our subcommittee level, the budget situation from a year ago is very different than it is today.
Oh,
so
no doubt.
We started a lot of these conversations. We were operating under a different financial picture. So I encouraged our subcommittee to not let the finances or lack thereof be an inhibitor towards those recommendations, to ensure that, because the budget picture hopefully will change over the next year as well, and hopefully we'll be in a lot better place over the next 2 or 3 years to be able to implement some of these systems as well.
Sure. And I would agree with Mr. Owens. It's expensive, especially mental health, because they're going to be a doctor of some sort. And we're just trying, just like you were talking about in one of these number 13, establishing each jail to size and resources to have mental health in jail. So I do not personally have a jail. I worked in a jail for many years. I can't imagine what the cost of actually having somebody on staff to do that. Because even in our smaller communities, I am amazed at how many calls we have all the time for mental health issues. Not opposed to having mental health help us. I mean, heck, we have enough mental health issues in law enforcement alone, more or less the general public. You know, so it's something that we can find ways to agree on these things. I truly do. But you know as well as I know, all comes down to money and time.
Yeah, and a lot of these really do come down to money. And in some ways, this ends up being a best practices type of recommendation than an actual, implement, if there's 100 jails, having 100 of those staff members. What might work in Johnson County or Shawnee County or somewhere else certainly isn't going to work in Meade County and some of these other places. But if we can build on the ideas and the recommendations of this committee and put some of these things in place in certain areas, then we can find some kind of a model that might work based on some of the things that are working in these larger areas. So, but yeah, right. It comes down to money, and it's in my opinion, the number one problem we're going to face as a state this next legislative session is how to balance the budget.
I don't want to see rob Peter to pay Paul type of thing, because in the smaller communities we can't do that.
Right.
But I'd really love to see more training of more people. I'm not even sure what training it is. The screeners. We need more screeners in this state. I don't care where they're from. We're doing it by teleprompt anyway. So I don't care where they're located. But if we can find ways to fund that, you wouldn't find any agency in Kansas fight you on that one.
And that's one of the big benefits we've seen come out of this pandemic is the use of telehealth, telemental health services, and building upon that is one of our recommendations that we're considering is how do we build upon that? How do we make those mental health services more widely available in our rural areas where you're lucky to get licensed, therapists and things like that to live there?
Yeah, I would agree.
I'd add to Chairman, this is Bill Persinger and Vallejo. All good comments, Chief. I don't take exception with those at all, and I can hear your commitment behind that. I will tell you that amongst the mental health center group statewide and the substance use disorders providers statewide, both on the public nonprofit side, working hard and have been for years, and will continue on some public policy initiatives. Another word for funding that will mitigate, some of the brunt of that work falling on law enforcement and provide you with some tools and assets. The moratorium at the state hospital, the expansion of mental health first aid, the expansion of Medicaid, a lot of other things that other people are working on to be able to bring some assets to mitigate what falls on that law enforcement officer who's trying to cover half a county in a rural area on a Sunday afternoon and got 3 calls going on. And we're trying to expand crisis intervention centers that are available 24/7. And I think you'll see some of these things happen at some point. But again, there's that issue of scalability that we want to be very, very sensitive to, so that we're not holding some ideal out there that folks in a smaller county can't aspire to. And the fact that you're looking at CIT with 8 officers, right on.
We have a very progressive assistant chief I just hired not long ago, and matter of fact, we have just started CALIA accreditation as well. We'll be the smallest agency in Kansas, because I think it's very important. If you look at the crime bill, That's one of the biggest things that they're pushing for is accreditation, and it would help because there's a whole mental issue proportion to that as well.
The other thing we're doing, again, Chairman Bill Persinger, the other thing we're doing, Todd, is to try to put not only licensed people out in the field, social workers and people with psychology degrees and so, but paraprofessionals, peer support workers, people with lived experiences, crisis case managers, and make those folks available at a whole lot more affordable rate than a psychiatrist or an APRN. So trying to expand that workforce that works very well in a rural area as well as an urban area. Chairman, I'll stop there. Thank you for all the time.
You're muted,
You're
Mark.
muted, Mark.
Oh, thank you. Sorry about that. We'll get used to turning it off so nobody hears me. No, I appreciate the conversation. Thank you, guys. I will echo one thing that Todd and Representative Owens said, Chief Ackerman, Representative Owens. And that is, as we go through our final report, I think we need to not only identify the issues that each of the subcommittees has identified as priorities, but I think we're going to need to also maybe do another layer of this in our discussions. And that is I'll echo what the approach that Heather Cessna took in our first, seems like it's been a couple hours ago now, but when she made her presentation from the public defenders, there's no way the legislature is going to be able to fund everything she needs in 1 year. But she's been smart about it and asked for a phased in approach. Here's the first priority. Here's a second priority, and talked about a phased in approach here. I think we're going to be in a tough position where we're going to need to ask for, these are the 20 or 25 things that we need to happen. Some of them will be very cost effective, like eliminating bans on certificates and licensure for certain jobs. That didn't cost anything to remove those prohibitions from someone's employment. But there'll be other things like the discussion that just took place, which will come with a price tag, and no one at the local level likes unfunded mandates from the legislature. So we're going to identify what's realistic, what's going to maybe be a phased in approach. And I think the other thing is, even if we're talking about pilot programs, let's make sure that something's funded in 2 or 3 places where you get the most bang for your buck, so that we can show that it's worth the effort, so that we can then find a mechanism for scalability down the road. I mean, I think we've said it out loud that this commission is probably needs to have another year. I'm not sure we've said this yet, but I'll go ahead and say it. And that is, this commission probably needs to be a standing commission over the next 3 to 10 years to make sure that these things we're putting into place. I mean, the 3R committee done 15 years ago was great, but they handed it off. It wasn't the right time, and it sort of died on the vine. Put a lot of work into this, and there's a lot of money at stake, both in potential savings and then also the costs associated with the front loading of certain programs so that we can someday see those potential savings. But I'm not asking everybody to sign up for another 5 years, and I'm not sure the legislature would give it to us. But this is a stepped up long-term approach I think we're going to have to take. So anyway, thank you all. If there's nothing else for Chief Ackerman, or excuse me, for Representative Owens on mental health, any other questions for Steve? Yes.
This is Spence Cohen. I was just going to pass on just a lot of what Todd and Bill just spoke on. There is the Special Committee on Mental Health Reform or Modernization and Reform. They've been meeting recently, and a lot of the discussions have been brought up. Just so you know, and I think it's not a duplication of what's going on, but I think they'll work hand in hand with what you guys recommend, as well as what that Reform Commission is going to recommend for mental health. So just wanted to pass on that's also being looked at there.
The work of that effort is been shared, I trust.
I don't know if that's been shared, but I am on that committee as well, and I'd be happy to pass that on, those notes to Mr. Owens, and I'm sure he has full access to all of that as well. So.
No, I'd love it if you'd share that with me, Spence. I haven't. I know that it's going on, but I haven't been able to keep up with it. So any specific recommendations or final report or anything they come up with, send that my way. I'd appreciate it.
Yes, will do. Thank you.
Okay, very good. All right. With that, I'll move on to proportionality sentencing. Chief Ackerman, you're the chair of that subcommittee.
Thank you, Chairman. Just Chief Todd Ackerman, Marysville. I would certainly like to thank Patrick and all his crew. They have worked with us. They even did help put a survey together with us with the Sentencing Commission through Scott's help. Yeah, they've been both crews have been a huge help to us. Now they went through most everything that we're looking at adding this year already, unless you want me to rehash it all. Also going back in to the report is almost nothing that we put in the first report got taken care of in the from the preliminary report that we submitted last year. A lot of it had passed the House but died before it got to Senate just because of the timing last year. And we're revamping it. And Scott and I are working tomorrow on it to put our layout. Then we actually have another meeting here on Wednesday at 2:30. And we're going to meet to hopefully finalize the, or at least put the full draft together and hope start to finalize the report. Unless there's any questions or anything you'd like rehashed or anything, that will be it.
Okay. Any questions for Chief Ackerman? Yep. Yep. Okay.
Thanks.
Yeah, thank you. Data management, we've needed to put a new chair in, but at the same time, understanding the limitations of that subcommittee right now with the lack of information available to them. I don't know that there's anything to add there, but data, let's put it this way, data collection, data availability has been mentioned many times in some of the other subcommittees. So I think we're still going to address it in other ways. It's been brought up in the presentations a couple times today already and broken out even in terms of some of the priorities for the various working groups that were referenced by Patrick's outfit. So data management, even though the subcommittee was not able to gather the information they wanted due to the post audits choosing a different route to go, I think we're still going to get to data management. So, all right, that leads us to Professor Phillips, re-entry. Anything to add to the discussion or updates from that subcommittee, Professor?
Yeah, thank you, Chairman Bennett. This is Jean Phillips with University of Kansas. I do have just a couple of things. We've met 3 times since our last committee meeting. Much of that has been with Council of State Governments, who has been amazing, and they have spent an enormous amount of time educating me on a variety of issues from which were sort of outside my purview. But I do have a couple of things to add based upon our committee meetings and some of the conversations we've had with the Kansas Department of Corrections, especially Margie Phelps, who's been really instrumental. So I'm aware that we have budget issues, and when we put our report together, we have an outline together and we're working on getting our draft. We are delineating those things that will not cost and those things that will. And some of them are going to be, they're just going to cost. And so we're kind of go big or go home, and we're going to put those things in there anyway. One of them is because there is an issue with lack of stability for housing. I'm just going to say we're doing housing, employment, and then support services, plus our driver's license issues still. DOC has expressed an interest or a need in having somebody who can monitor what happens to individuals once they get into those master leases and they're there for a period of time. And it's come to our attention that after 90 days, DOC, nobody really is keeping track of folks. And so with housing issues, what happens to those individuals? And they would like to, at least it's been discussed in our committee about whether or not we need to try and have a way to monitor what happens to people more long-term to make sure that they continue with their housing after that 90 days or after 6 months, right? So once the master leases, and can they continue with their housing stability? And so in addition to all of the issues that we talked about already with Council of State Governments, we've got that sort of issue on the back burner. The other couple of things that we have added to our list in terms of housing is the need for more master leases. And so that we have some place as we're working through creating these partnerships and creating access to more stable housing, there's places for these folks to go, at least in the short term. And lastly, on housing, there's been a conversation about needing a facility for individuals with disabilities, that there are some folks that cannot go back out to the community and live in a housing on their own, whether that's because of mental health or elderly, whatever it happens to be. There is a need that's come to our attention from Kansas Department of Corrections to have a housing facility where they can put individuals who are unable to live on their own. Employment, the only issue I would add to employment on top of what Council of State Governments addressed is that there has been a conversation about enhancing the process within the DOC. Right now, they evaluate and assess an individual's education and employment needs, but they need they don't have the resources for those assessments when they leave RDU, reception and diagnostic unit, when they leave RDU, to follow them to their whatever facility they end up being placed in, so that that information goes there and follows them through, and that they continue with the kinds of education or training that they need. They just need to have a little more consistency in how that follows individuals.
Is that a records management issue, you think, or is that?
Well, I need to explore that a little bit more with Margie Phelps and a couple of folks from KDOC. That is something that just kind of came up in our last meeting. And so that is one thing that we need to sort of hammer out in the next 2 weeks to put into our report if we decide to put that in the report. But that is an issue we're looking at in addition to all of the stuff that Council of State Governments talked about. But yes, I think that there is, my understanding is that some of it is a resource issue, that the DOC is doing part of this now, but they just don't have the resources to do like a full follow through. So I'm not sure if that's data or if that's personnel, to tell you the honest truth, Chairman.
Fair enough. Thank you.
Yeah, so then the only other thing I would add is that we're still following through with our driver's license proposals that we had put, the legislation we put forward last year. So to try and make sure that individuals can get their licenses back so they can get to their jobs. Otherwise, everything else in terms of employment, training, housing, the licensing barriers, the SNAP and TANF barriers, all of that, we're sort of adopting those proposals that were provided by Council of State Government.
Very good. Any question for Professor Phillips? Okay. That leaves us with the Race in the Criminal Justice System Subcommittee. I have a draft report that I've given to Mark McCormick, who's, I think he's referenced as the co-chair or the sub-chair of the committee. I drafted that and sent it to him, and he's gotten back about a week ago, I guess, and got a message from him today that he'll have some edits for it. And once that's done, I'll send it out. I was waiting on that I wanted to make sure I had that back from Mark. And then Jordan is going to try to set us up for a week from tomorrow for a lunch meeting to go over that. That subcommittee is obviously the latest subcommittee has been in place the least amount of time. So try to keep our goals modest in terms of trying to start a conversation, identify maybe sort of the track we did last year with the overall commission, the low hanging fruit sort of things, the things we could agree upon early. With the caveat that it's understood that race in the criminal justice system subcommittee is not just didn't have the time to do a deep dive. But with and if we get an extension, it's everyone's expectation that the harder conversations and the more meaty issues will be addressed this coming spring in that subcommittee. But I'll have a final report for the members of that subcommittee hopefully by tomorrow, and send it out, and then we will have our meeting next week and have it ready for try to meet the October 26th deadline. Okay, any questions regarding the Race and the Criminal Justice Subcommittee for me, the acting chair of that subcommittee? Okay. All right, well, the last thing on our agenda is discussion of goals for the December 2020 final report. I think frankly, that's a little redundant. That's essentially what we've done all day, is talk about goals and where we're at and even get into the weeds a little bit in terms of prioritizing and money issues and budgeting and all that. But is there anything else that anyone wants to raise with regard to discussions for goals? Excuse me, Professor Phillips, see your hand raised.
Yeah, Chairman Bennett, this is Jean Phillips. I may have asked this at the last meeting and it may have come through and I just missed it in Jordan's emails. Do we know what form we want our final report to be in? So as we're drafting, we know what
it look like.
Yeah, what it's supposed to look like. I mean, do we have a particular format?
I know I've seen it. Jordan, I'll let you address. I thought it had been sent out, but I'll candidly, as the chair, maybe I saw it and he just hasn't sent it to everyone else. But I know I've seen it. Jordan, is that something been made available to everybody yet?
Thank you, Mr. Chairman. Jordan Milholm, Legislative Research. I did send out an email, but it's been several weeks. I can resend it to the chairs if you'd like, and that way they can have it.
If you would. Yeah, thank you.
Mm-hmm. And we've got an example report on there and the dates on there as well.
Okay. Very good. Thank you. That answer your question, Professor Phillips?
Yes, thank you.
Yeah. Any other questions, comments before we wrap things up? All right. Well, I appreciate everyone's work. I will say, when we first started this off, I was impressed by how much we could get done in a short amount of time in 2019, last fall, and the size, scope, and breadth of the report that came out as that interim. But I would say I'm even more optimistic that we can really have put together a plenary review of the state with some really substantive, realistic goals. Now, whether the money is there because of COVID, I get it. We're going to have there'll be some tough conversations, but and I would again just sound like a love fest here, but I'll say it again. I'm very appreciative of the Center for State Governments and Patrick and his crew, what they've done. I think we would have reached many of the same conclusions, but they would not have been supported by the degree of data, and they would have been ideas as opposed to defensible positions supported by objective information. So I really do appreciate the work they've done. I think the state's going to benefit mightily from their efforts and from their willingness and ability to work with us. So I don't want to get the cart before the horse, but I'm pretty excited about the level of sophistication this final report might very well look like, or might bring to the legislature. So thank you to all of you for your work. A lot of folks put in a lot of effort, and not quite there yet. We're getting there, but we'll have at least one, if not two, meetings in November where we're going to get down to the reports and brass tacks and start identifying not only what we want to do, but the order in which we suggest to the legislature that they do it. I'll say one final thing here that I think it's kind of a late entry, slide in at the 11th hour here, but Heather Cessna's report today, while it's not something that's been discussed widely for the last year, year and a half, I think it can slide in through the auspices of the race in the criminal justice system, because that is a conversation we've had in there, the need for robust public defender system, and insofar as that is not a racial thing in and of itself, but it certainly impacts race. It impacts everybody in the criminal justice system, but maybe no place more than in the racial context. But what I'm getting at, long way of saying this, is that to me, granted I'm a lawyer and so I deal with public defenders all the time, but that to me is going to be, I'll just telegraph here, that's going to be one of my priorities. Put a lot of work into this, and it's been an underfunded, try to be polite here, but an underrepresented component for a long time, and we need it. We need a robust public defender system. So just let you all know that that's going to be one of my priorities, whether it's the whole thing, her whole first phase or not. So anyway, all right. Anything else?
Chairman Bennett, this is Jessica Dummy with the AG's office. When is our next meeting day?
I have November 9th and November 23rd, and then our December 1st is the report date. So, Jordan, did I get that right?
Thank you, Chairman Bennett. Yes, I believe November 9th is correct for our next meeting.
The November 23rd, just everybody, I think that we pulled that and put that on the calendar because it's the week of Thanksgiving. Not great, but it's also probably not a lot going on that week for people. So it's our kind of fail safe as our last report or our last opportunity to get together before that December 1st report date. Okay. All right. Thank you, folks. Appreciate everybody's time and attention. It's been a long afternoon, but a productive one. So we will see you all in subcommittees and then again on November the 9th. Everybody take care.
Thank you, Chairman.
Thanks, folks.